Good morning, everybody. I'm sorry I can't be with you in person. I'm down in the Bay Area today, but I wanted to talk with you about a Lis Pendens. That's a topic, an issue that comes up from time to time, I'm sure, in some of your transactions. A Lis Pendens is the Latin phrase that lawyers use for a lawsuit is pending, meaning that there's some lawsuit having to do with the property that you're involved in. It's a term that gets thrown around a lot, and I'd like to talk to you about what it means and essentially that it's really not that easy a thing to do. It requires some thought and some input and some work on the part of somebody who says they're going to put a Lis Pendens on a piece of property. So I wanted to talk to you about that. Okay, first of all, a Lis Pendens is something that's defined very specifically in California law. That is, there are statutes that are written by the legislature, and these statutes are very strict and very determinative of what a Lis Pendens is and how a Lis Pendens operates. So, under the law, in order for a Lis Pendens to affect a piece of property, the underlying claim or dispute has to involve what's called in the law a real property claim. And that's a defined term in the California statutes. And what a real property claim essentially is one of three things. It means that some person who's a stranger to the transaction that you're involved in has some claim that they have some right of title, that is ownership of the property for one reason or another, or that they have some right to possess that property, such as maybe they claim to be a tenant or to have some other right to be on the property, and that your transaction will interfere with that, or that person has some sort of claim of easement on the property. So a common thing would be, so you have a piece of property and the neighbor claims they have a right to a prescriptive easement. We've talked about that in the past, and that would be a real property claim that might affect your property. So if that neighbor says, hey, I've got a right of prescriptive easement across this property you're selling, and I want to make sure that claim is recognized, they might say, well, I'm going to file a Lis Pendens to make sure my claim is recognized. Well, there's some other things that need to happen in order for that person to do that. First of all, next, a Lis Pendens is a written document. So that means that someone has to write up this document, and then it has to be signed. It's got to be signed either by the lawyer for the person who's making the claim, or if the person who's making the claim doesn't have a lawyer, the claimant himself or herself has to sign the document. Okay. That seems simple enough. But there's more to it after than that. So once that document is written, it has to be put in the mail to all interested parties, that is the people involved in the transaction and the people who own the property. And that means doing some research, going to the assessor's office and finding out who owns all that property that the claim is being made against. So after the mailing happens, then the document has to be recorded in the county recorder's office. That also seems simple enough, and it generally is. But here's where the Lis Pendens is most difficult to obtain, and that is there must already be a lawsuit. So you can't just go out and record a Lis Pendens willy-nilly. There has to be a lawsuit that's actually been filed that involves a real property claim. So we go back to the example of the neighbor says, hey, I've got a prescriptive easement against this land that you're selling, and I'm going to put a Lis Pendens on the property. They can't just go down to the recorder's office and do that. They have to file a lawsuit. That means either hiring a lawyer to do it or doing it themselves. Going and filing a lawsuit that says, here's my lawsuit. I claim to have a prescriptive easement against that property over there, and I'm asking the court to say, yes, you do have that prescriptive easement. So if there's not a lawsuit pending, there is no Lis Pendens. And here's an interesting thing. It has to be a lawsuit. If for some reason the dispute is one that's being arbitrated, that is, where there's a private judge making a decision on the case, not the court, that doesn't count. It has to be an actual lawsuit in order for there to be a Lis Pendens. Okay? And ultimately, the effect of that Lis Pendens, if all of these things are met and somebody does record a Lis Pendens on this property, and the lawsuit is ultimately determined in that person's favor years down the road or whatever period of time it takes. So the neighbor who says, I've got this prescriptive easement, if that neighbor wins that lawsuit, then what happens is that neighbor's claim relates back to the date that the Lis Pendens was actually recorded. So that means that anybody who buys the property or acquires title of that property later is still subject to that claim of the Lis Pendens that had been filed years before. So that's sort of the simple explanation of what a Lis Pendens is and how a Lis Pendens can be put on property. Another time we'll talk about if you're in a lawsuit where there's a Lis Pendens and it affects your property, and you want to somehow have that Lis Pendens taken away while the lawsuit is pending, there are ways of doing that. We'll talk about that in another session. Now, let me also do this. Not so long ago, we had a talk about means of holding property. You might remember that. We talked about joint tenancies and how joint tenancies involve a right of survivorship. That is where if 3 people own a piece of property in joint tenancy among themselves, one of them dies, the other 2 automatically now own the property. Paul asked an interesting question, and I didn't know the answer to, and I've thought about it some more, and I think the answer is this. And the question was, if you have 3 people who own property in joint tenancy, and one of them decides they don't want to be a joint tenant anymore, and so they break the joint tenancy, does that break the joint tenancy as to the other 2 who want to remain joint tenants? I think the answer is no, it doesn't. So if person A, who's a joint tenant among the 3, signs a deed to themselves saying, I'm now a tenant in common, which means no right of survivorship. Persons B and C still have the joint tenancy as between the 2 of them, so the B and C, if one of B and C or C passes, then the other automatically becomes the owner, but they're tenants in common as to the guy who broke the joint tenancy. That was the question Paul asked, and I didn't know the answers, but I think that is in fact the correct answer. Thanks, have a great day, talk soon.